number 73, matter of independent insurance agents and brokers of New York versus the New York State Department of Financial Services. Counsel.
Good morning, Your Honors, and may it please the Court. Sarah Rosenbluth for Appellant, Department of Financial Services. I'd like to reserve 2 minutes for rebuttal.
You have 2 minutes.
Thank you. The best interest standard, which has now been adopted in at least 28 other states, is a common sense regulation that uses clear and commonly understood terms to regulate insurance agents and brokers. It is a rational exercise.
Counsel, good morning.
Good morning.
What is the evil or the concern that the regulation is intended to address, and how does the language match that goal?
Yes, Your Honor. The legislature has made the judgment, as evidenced in a number of statutes, that it is the policy of the legislature in the state of New York that the department shall supervise the individuals engaged in the business of providing financial services and products and shall ensure a high level of honesty, transparency, and competence when consumers seek out the assistance of these financial business people. And so in terms of the language, what I would like to point to and primarily is page 306 of the appendix, and that contains the regulatory impact statement where the department sets out its authority, and it explains that when it instructs producers to act in the consumer's interest rather than their own financial interests, the department says that goes to the heart of what it means to operate in an honest and trustworthy manner.
Counsel, it seems as if the industry has its own set of fairly similar standards to which they hold themselves. Could we not just rely on their own self-regulation to do the job in the manner in which it appears both of you want them to do it?
No, Your Honor. First of all, this is amply within the statutory authority, and the department also considered comments during the notice and comment period by the industry to the effect of, there are existing standards that are similar, can't we just rely on those? And there are important differences between this rule and other existing sort of rules of self-regulation and also federal rules. Other rules, for example, might require producers to put consumers' interests ahead of their own, but does not prohibit them from considering their own interests. So this goes meaningfully further than existing regulations.
That gets to the matter at hand.
Sure.
Which is vagueness. Are there differences between your regulation and the ones that the industry imposes on itself that somehow, in the view of at least one lower court, rendered it vague?
No, Your Honor. So there are certain differences in terms of the meaning, the definition of recommendation, for example, and I'll refer here to the model rule. That's not the industry's self-regulation. I'm not exactly familiar with the terms of any self-regulations, but for example, the model rule.
Their ethics standards. I think they have a certain ethical code that they subscribe to.
Sure. I'm not exactly familiar with what those terms would be, but in any event, the terms of this regulation have been adopted in substance and in some cases verbatim by the National Association of Insurance Commissioners, which sets forth national standards, and that has been adopted now by at least 28 other states. So I think that really widespread adoption by more than half the states in the country shows that the terms at issue here are not hopelessly unintelligible. Certainly other...
Is our review here for rational basis?
On
the constitutional question.
On the constitutional question, I think that's one way of looking at it, Your Honor. I mean, certainly the agency has authority to, when it is delegating within its sphere of, when it's regulating within its sphere of delegated authority, it does enjoy a presumption that it's acting rationally. And certainly that's not just a matter of presumption here, but it's borne out by the record.
And so if the regulations exactly duplicated the industry code, what about that would make it unconstitutional?
Nothing, Your Honor.
And if it differed?
I mean, it's permitted to differ. The agency exists to regulate, as a regulator that represents different constituencies than does any self-regulating entity of the industry. So it's absolutely permissible for it to differ meaningfully and, in put different emphases than does any self-regulation.
Counsel, when we look at the vagueness test and we look at notice, the notice prong, person of ordinary intelligence generally expressed, is that different here? Are we looking at a different audience? Are we considering this regulation through the lens of a very highly regulated industry?
Yes, we are, Your Honor, and that is set forth, that standard is set forth, for example, in the Hoffman Estates United States Supreme Court case, where it talks about the difference in vagueness standards that would apply, for example, in criminal statutes where, any ordinary person is regulated and also faces deprivation of liberty by contravening that statute on the one hand, and on the other hand, economic regulation that does regulate, as you say, highly sophisticated and highly regulated entities. And it's worth noting here that insurance is one of the most heavily regulated industries nationwide. And certainly in
So
the
are you
state too.
suggesting that the vagueness standards that we apply in criminal cases, when you're considering insurance, should be no less? Because one involves liberty, the other the contrary.
The vagueness standard in this case that applies to economic regulations is less strict than that applies in the criminal context. Regardless, I think we satisfy either test. But one reason why, in addition to the sophistication of the parties at issue, another reason why we apply a less strict test to regulated, business entities is because there is that opportunity for clarification. And the terms here are clear, even without
Okay,
resort to
so
any.
now let's get to that one.
Sure.
Which is where I was hoping we get. So reasonableness, I think you have a very good argument on that. I'll ask your adversary about that. But suitability, how is that not vague? That seems such a broad concept. So many factors go into that are idiosyncratic for any particular client or customer.
Right. So first, the term suitable is itself separately defined in section 224.3H, and then there is in subsection G, there are those factors that are the quote-unquote suitability factors. Now, the fact that they may call
Well,
for
how
the...
is suitable defined?
Suitable is defined as in furtherance of the consumer's needs and objectives based on the information provided by the consumer. And the suitability information admittedly calls in some instances for subjective information from the consumer. Some's pretty objective, some's age, income, marital status, and the like. But there are some admittedly more subjective factors that the consumer can choose to answer in a variety of ways. For example, financial needs, objective, risk tolerance. But the fact that the regulation calls for the solicitation of subjective information doesn't...
It is possible with that particular term, though, even with the factors and other, let me call it guidance for a moment, that you're providing for let's just say the agent for the moment. The agent thinks is suitable that the individual themselves would never think is suitable. How do you resolve that issue? Do they always have to defer to the customer, the purchaser's idea of what is suitable, which may not, obviously, because you're going to an expert, which may not be a result of a full analysis of all the relevant concerns?
Well, the definition of suitable is tied to the consumer's own financial needs and objectives. So assuming that there has been no miscommunication, the consumer and the producer should be agreeing on what is suitable. And just further to your point about the potential...
I'm sorry to give it, does that mean that they have to agree on what are the concerns and factors that go into that calculation to make the determination as to what is suitable?
I mean, certainly the producer is exercising some expert judgment, but it is all based on what the consumer, on the information that the consumer provides. And importantly here, there is no requirement, as petitioners suggest, for the producer to somehow displace individual autonomy to override consumer stated preferences.
So what you're saying, as long as they have the relevant information provided by the producer, the ultimate decision can be made by the consumer, but they are still fulfilling their responsibilities?
That's exactly right, Your Honor. And that is underlined in Section 224.4F, which says that a producer has no obligation and will not be exposed to any liability if the consumer decides to go against his transaction, if the consumer rejects the
The
transaction.
list of suitability information, is it exhaustive or is it exemplary?
It's exemplary, Your Honor.
So there
it's
could be other types of suitability information not listed. How is the producer supposed to know what that is?
Well, presumably in such a case, a consumer will, in the course of an open-ended conversation, might refer to any pieces of information that might be highly idiosyncratic to that person, and therefore would not be captured in the exemplary list, but, that consumer might inform the producer that this one thing happens to be really important to me. So there's no need to sort of be clairvoyant in
But what if the client doesn't tell you something, but DFS thinks, well, anyone with this kind of expertise who's working in the best interests of the client would have asked about those things? Who's liable in that scenario?
Well, if the producer solicits, certainly if the producer solicits all the examples of suitability information, there would be no requirement to somehow make up additional factors to solicit. There might be a scenario where a consumer suggests so that something's
But
important.
then you're saying the floors set out are the factors,
Are the
are the
floor.
floor,
Yes.
and you're not expecting them to exceed that. If
They
they do
need-
under
they
the
need not.
scenario, that's fine.
That's
But if
right.
they don't, they've complied with the responsibilities as DFS sees it?
Yes, in most cases, yes. I could potentially construct a hypothetical in which a consumer suggests that there's one idiosyncratic piece of information that's extremely important to that person, and the producer probably would want to understand that and base a recommendation on that. But I can't, off the top of my head, consider
But
what
it
that...
sounds as if you're saying essentially that if the producer goes through the checklist of the suitability information items that are in the regulation, that's a safe harbor.
Yes, and that's almost right, Your Honor. Certainly going through the checklist of suitability factors is an important step. There are a few other steps that are listed out in Section 224.4B, but yes, that's exactly right. And again, one of the most important points I would like to make this morning is that the best interest standard calls for adherence to a process. It does not call for any particular substantive outcome.
Counselor, you note in your briefs that insurers can get additional information if they can call in and ask for help with guidance with the regulations. First, how do you think that helps us in a vagueness analysis? And second, couldn't it be that if so much support is needed, that in fact the regulations might be too vague?
Sure. So with respect to your first question, sort of doctrinally where that fits in, I think, is, as again, I referred to the Hoffman Estates case where it says that, the reality of a highly regulated industry is that there is that opportunity for a clarification, a give and take, perhaps a resort to administrative process, and here we detail in our brief sort of how that information is communicated. So that really alleviates the concern that anyone's going to be, for example, subject to substantial fines or penalties. It really alleviates the notice problem. They have really a full opportunity to clarify, and more than just resort to the agency. Another critical point here is that they're under supervision by insurers. All of these producers, they're not islands here. They're working with insurers, and there are very important duties of supervision that are, again, set out in 224.6. And so the insurers, and already have been really a huge resource here for producers in prescribing forms, really making it clear to producers how they expect this to go. And there's training and the like. So that training, again, also is another opportunity for clarification. To the extent that clarification is needed. I certainly don't think that weighs against, or that weighs in favor of vagueness here. I
Thank you,
think that's,
Ms. Rosenbluth.
okay.
May it please the Court, Howard Kronberg from Kydell, Weldon, and Cunningham for petitioner respondents. Your Honor, I'd like to preface this by saying this is my first time arguing before this Court. I'm honored to be here today. I would have been a little nervous anyway with all of this, so if I constantly get dry mouth and need water, please don't let it indicate.
Those are the people you need to be worried about.
Okay. It's not an indication of any non-belief in my position. I remember from law school being taught that when there's a complicated issue, go to your best argument. And it's two and they're interrelated. The first is, it is unconstitutionally vague. And the second is, it reverses your decision in Murphy v. Kuhn. It completely changes the common law standard to be applied here. Preface this by saying, my first job in law school, my first year in 1981, was as a law clerk at Wegenmeyer's, working with Dennis D'Antonio, who I understand yesterday argued an insurance case before you. I've been doing it ever since. In 1987, I started to do E&O defense and have been doing it throughout. We are the successor, our law firm, to Lustig and Brown, which argued Murphy and Hoffman and Chase Scientific. We've been counsel for the Big I, IABNY, for many years. We're the attorneys, my partner Jim and I, that literally get the call every day, in the morning, throughout the day, by insurance brokers with this question: what do I do? Insurance agents and brokers in the state of New York want to do what's right by their clients. They want to do what's right, of course, by the DFS.
And counsel, what
Yes.
terms specifically in this regulation are they having trouble with?
All of it, Judge.
But tell me some terms. We can say all of it, and there's some broad language in the appellate division, but could you identify for me the terms that you're getting calls on or you think specifically are vague?
Okay. Suitability in the regulation is a tautology. You cannot define suitability and then say suitability is defined as what is suitable and documents that are suitable. One of the judges asked about the checklist of suitability documents. That's incorrect. It's not a checklist. DFS is wrong. It's examples, and therein lies the problem. One of my great problems with this regulation is this. Murphy said, procure the coverage requested. It's a bright line. To remember this, and this is going to sound crazy, I had the word sausage written in my papers. Why? Because as we all remember growing up, nobody wants to know how sausage is made. We don't care. If it's delicious, that's fine. Sausage is, making of it is outcome determinative. Murphy is outcome determinative. The process doesn't matter. It doesn't matter how a broker or agent gets the insurance as long as it's what they wanted.
But counsel, it seems as if the current thinking is these products are so complicated now that what's requested is very often the result of a recommendation made by a person who's in a position, at least from the perspective of the consumer, to know what it is the product is and how it works. And that's going to greatly affect the consumer's decision about which product to select. And this regulation, to me, distilled to its simplest form,
Right.
is just a command that you think about your client before you think about yourself. What's wrong with that?
Nothing, Judge. I don't think this does that, though.
But again, Judge Garcia asked you specifically
Right.
about the questions that you were called upon to answer from clients. So what is the question that is most asked that is a problem with this reg?
No, my apologies if I wasn't clear. We're called on to answer questions all the time about regulations. We have not gotten anything on this yet, okay?
But so the suitability information definition has existed for something like 15 years? And you're the go-to people and nobody has asked you what that means?
No, they haven't,
So
Judge.
maybe they understand it.
Correct. I don't think so.
What I heard Ms. Rosenbluth say, and maybe you don't agree,
Right.
was that at least as to the suitability information,
Yes.
if a producer goes through that as a checklist and asks the client about those sorts of information, that would be a safe harbor with a couple of caveats. One caveat is that there's no obligation on the producer, but if the potential customer says, well, wait a minute, there's some other things about my situation you ought to know, the producer's got to take that into account, although there's no obligation to ask for that. And there are other pieces of regulation outside of the suitability information that the producer's going to have to comply with as well. But essentially, that checklist is, she said exemplary, but if you complete it, that's a safe harbor. Would that be vague? If that's the interpretation?
If that language is specific in the regulation, which I don't read it that way, maybe that would be different. But I don't.
The maybe is let's see if we can get past the maybe. Suppose that was the definitive interpretation. This is a safe harbor if you go through that checklist. Would you still have a vagueness problem?
On that particular part, no.
Okay.
I don't think I would.
So then what are the other parts that you would have a vagueness problem with?
Whose interest is at stake? Because as we litigated in the Vestal case, which you refused to hear from the Third Department, I represented a life insurance broker who was asked by an attorney husband to get life insurance that he was absolutely not qualified for because he had drug and alcohol problems.
Yeah, but isn't there a definition? The consumer means the owner or prospective purchaser? What's vague there? There is a definition. Consumer means the owner or prospective purchaser.
But that's
What is vague in that?
because the best interest, the way the regulation defines it, and is admitted in the reply brief.
No, I'm asking you about that definition. What's vague in that? Consumer means the owner or prospective purchaser.
Because
Of the policy, excuse me.
Because it's an incomplete set.
Okay.
It's the consumer, it has to look, and the agent has to look at the best interest for the consumer. But they admit in the reply brief, and I'm happy to cite the exact page, that it could also mean the beneficiary of a life insurance policy. So
No,
it's-
it doesn't say that. But I'm happy to see what page you're talking about. I think they've clarified that it's this definition that applies, but if I've misread their brief, that's fine.
At page 4 of their reply brief,
Okay.
the needs of the beneficiary should be considered, first paragraph, last sentence. Now, they go on to say, yes, it's the
Okay,
consumer.
but how is considering, that sounds like a consideration, not that that's the consumer.
Fine, because to go back to the Vestal case, the life insurance policy that the applicant wanted was completely unsuitable, one for himself and for the needs of the beneficiary. Okay? The Third Department upheld dismissal for us based on Murphy, saying, you asked for this, you got it, and that's fine. Murphy will no longer be good law. This regulation reverses it. And to me, it's absolutely clear. And if I may,
Let's say we disagree with you. Let's say we're not so clear. Do you lose?
I'm sorry, Your Honor?
Let's say we disagree with you about this, your argument that this overrules Murphy. Let's say we do not see it that way. Do you
Okay.
lose?
Yes.
Since you've already said the factors, you agree with Judge Wilson, the factors
Yes.
of safe harbor, you said, okay, with respect to that, maybe that resolves it. What else remains? A consumer is defined, what else?
You mean, what other parts
Yes,
are
what else
vague?
makes it vague? I'm trying to get to Judge Garcia's question. What are the actual parts of it are vague?
The vagueness comes from the fact that this is, as mentioned and is clear, it's a process. You're going to have the DFS investigate agents and brokers about a process. And if I may, I think there's actually something dispositive of my argument, which both I cite at page 23 of our respondent's brief, and DFS cites at page 4 of their brief, which is an official DFS, there's a hyperlink there. And it's a 16-page document that clarifies the regulation. Now, from my perspective, just as a layperson, I would say, if the regulation is clear, not unconstitutionally vague, why do you need a 16-page explanation of what you were trying to say? If, as they say in their papers, they're the experts and they've been doing this and they took all this time to draft this regulation, why do you need 16 pages to clarify it?
I suspect that some of your insurance policies are longer than 16 pages and pretty small type.
Very much so, Judge. And the law in the state of New York is that an insured is bound by that policy, whether or not they can even speak English or whether or not they have read it. But that's not going to apply here. I think it's really telling that at the very first question, again, it supports my view that this overturns Murphy, and it says that, quote, "The department views the best interest standard more as a process than as a singular outcome." Murphy is an outcome case. This regulation
But
by its...
isn't that simply recognizing the obvious, that a consumer has particular concerns? Perhaps some are shared by other consumers, but they may have a unique situation. And as Judge Canataro has already said, what is the regulation requiring but that the person who's trying to provide these expert services to the consumer is not thinking about how deep they can make their wallet, but what are the needs of the consumer? That that's your priority. Yes, of course, you're going to make a living off of it, but the priority is the consumer, not you.
Your point is well taken, Judge, and I'll go back to what you said in 1997 in Murphy, which is insurance brokers and agents are not financial managers, and that insureds are the best ones to know what their needs are. And I think that was true
That's why
then.
it's about the recommendations that you make. The consumer can make their own decision whether or not they're persuaded and think, yes, that makes the best sense for me. Thank you for the information.
I think you're correct, Judge, and I think you can drive a truck through what a recommendation is or isn't. As somebody who handles the litigation when everything falls apart, I will tell you, every plaintiff's attorney, like Mr. D'Antonio who argued yesterday, who handles these cases on behalf of plaintiffs, they're going to argue that any statement was a recommendation. What's going to happen is the courts are going to be inundated with cases trying to clarify what these terms mean.
Counsel, suppose we determine that it's not unconstitutionally
Yes.
vague. What are you asking for? Remittal for the remainder of your issues or for us to decide?
I'd like you to decide, but I'm glad you mentioned that, Judge, because this is how I'd like to conclude. As I said, I think if you let this regulation stand, there's going to be more litigation than anyone can imagine, and it's going to go against the admonition in Murphy that warned against opening up the floodgates to more litigation. The worst that can happen is if you affirm it, is we'll go back to the drawing board. I mean, it won't be the end of it. The DFS and my clients are going to sit down together, I would like with our involvement, and figure out something that's workable. I don't believe it's the end of the line. Thank you for your time.
Thank you, Counsel.
I'd like
Counsel, can you address this issue about the reply brief, page 4?
Oh, sure. That's about the consideration of the interest of the beneficiary. Sure. So as Your Honor identified, the regulation does define consumer as the owner or prospective purchaser of the policy. The guidance makes clear that the needs of the beneficiary should be considered to the extent that they're relevant to serving the purchaser's interests. To the extent that they diverge in some ways or that the purchaser does not have a certain sense of what the beneficiary's interests are, the needs of the purchaser control.
And what do you say with respect to the claim that there will be much litigation on the issue of recommendation?
So my first point, Your Honor, is that this regulation has been in effect in some form or another, including with a similar definition of recommendation since 2010, so for over a decade. There are 0 reported cases of consumers bringing lawsuits to enforce Reg 187. So I think that should give this court comfort that we're not opening the floodgates
Well,
here.
but what's different? Obviously, something's different.
Sure, there are differences, and obviously it is a more consumer-friendly standard. However, there are a number of safeguards built into the regulation that mitigate against this risk of inundation, as it were. For example, the regulation makes very clear in a number of places that neither the department nor consumers are to second-guess producers' judgments made with the benefit of hindsight. The definition of best interest ties the duty to the circumstances then prevailing at the time of the recommendation. Similarly, the definition of suitability information ties.
Are you making the producer fiduciary?
Absolutely not, Your Honor. The fiduciary duty is an ongoing duty that basically requires a fiduciary to act in the interest of another on an ongoing basis, and usually exercises discretionary control over managing the beneficiary's assets or making decisions on behalf of the
Counsel,
beneficiary.
what about this argument that really, even though the regulation focuses itself towards a recommendation, the whole interaction between the producer and the prospective client is the process of making a recommendation. So basically, everything that takes place in the context of that relationship could conceivably fall under the umbrella of recommendation.
Right, well, the definition of a recommendation is tied to something that reasonably is interpreted as advice and results in the consumer entering into a transaction in reliance on that advice. So there's going to be a limited subset of statements made within that interaction that actually are reliance-inducing. And then just to briefly respond to my opponent's invocation of the Vestal case, again, as this sort of harbinger of bad things to come. That case would not have come out differently under this rule. In that case, the husband made material misrepresentations on his policy, on his application. Under 224.4F, the producer is not liable if it is later discovered that a recommendation was made on the basis of materially inaccurate information provided by the consumer.
Counsel, on I think Judge Singus's point, if we were to decide your way on the vagueness question, what do you think about the rest of the issues? Back to the appellate division or for this court?
No, I agree with Mr. Kronberg here that these are pure questions of law, and the court should proceed to dispose with the entire appeal and all the issues presented.
Thank you, counsel.
Thank you.